Hello, everyone. Today we have election with the speaker Yulia Salехova, and the election will continue 1 hour, and after this we will have mini coffee break. So let's
start.
Let's start. And this is your speaker. I hope you will enjoy this. If you have some questions, please raise your hand and I will go to you and give you a microphone.
Yeah. Hi, everyone. First of all, please accept my apologies if you were waiting that girl in blue dress. It's the first lesson of this lecture. Don't trust everything you see online, because it will be me who will give you a lecture. So, short introduction. I am Master of Law in Information Technology and Intellectual Property Law. I did my master's degree in Germany. Also, I work as a compliance director. I am certified anti-money laundering specialist, and well, you can see this. Just what's all this about? It's something to let you know, to let you understand that in some points you can really trust my opinion and my expertise. So, topic of today's discussion is personal data for developers, but as I know, how it works. Oh, as I know, not all of you are developers, at least not all of the people in the list who actually work as developers here. Can you please raise your hands? Like none of you. Nice. Well, somehow I was more oriented on this types of like people, but I hope that you'll find something interesting and new for your work, for your professional development anyway. So why should developers care about the personal data and how to protect them? Let's just ask the simple questions. Who design the architecture of applications? Who integrate other systems into your own? Who create the code and who steal this code from GitHub? Who knows better than all managers altogether which types of data are collected, where they're stored, and how they are processed? It's actually developers. Who sees system vulnerabilities more clearly? And, well, the most important question, who create anti-fraud systems and systems to prevent hacking attacks or data leaks? Yeah, it's developers. And that's why they should be aware of personal data regulations and the problems that can arise. Formally, it's the business, business owner who's responsible for legal compliance. Like even more formally, it's a director who is legally responsible for everything that's going on in the company. And it's true not only to developers, but like for all of you. The most responsible person for everything that's going on is your director. But anyway, if you are working, especially in startups companies, quite common situation when you don't have lawyers or compliance specialists. So people who work with these things directly, who are educated to find problems, vulnerabilities, and potential non-compliance risks. And all the decisions are made by a small group of people who are creating the startup. So it might happen that each of you will be responsible for some decisions on a particular stage of development of your company. And yet, even really large companies with a very big legal departments and compliance departments are still from time to time are fined or are placed in the middle of the scandal. probably some of you have heard about the last situation in Kazakhstan. It's just a couple of days ago. It was found out that a very huge amount of data leaked. Who heard about that? 16.5 million people of our citizens, data of these people were disclosed. 16.5 million. I mean, do you know the number of people living in Kazakhstan? It's almost all of our adults, and all the data are disclosed. Of course, not all of them, but names, individual identification numbers, and addresses, and some medical information. It's not yet obvious who's responsible, but anyway, the company who let this happen will be definitely fined, will have a really huge reputational risk and damage. But the biggest problem here is not about that. It's not about fines or something. It's about fraudsters and the fact that someone's granny or grandpa will become a victim of fraudsters because of this leak. Because it's how it's happened. Data is on the internet. Fraudsters use this data. Someone loses money, loses assets, and sometimes it can be really damaging. Kazakhstan, of course, not the only country where we have problems. And for example, there was a case in the United States where the company created the application that was aimed at children, but it stored parents' email addresses, and these addresses were not encrypted. So they ended up violating the Children's Online Privacy Protection Act, and this company was fined. Food delivery startup used someone else's SDK, and this SDK collected data about location of users. So official order and a temporary suspension of operations, because you should not do this. You should not transfer data to third countries without notification, without consent. If your application don't have the clear mechanism for revoking consent to the collection and processing of personal data, only one complaint and you will be fined. So nowadays, many countries, including Kazakhstan, are rethinking the role of IT in collecting and processing personal data and storing, of course, because we are creating the really huge databases containing a huge amount of data of individuals. And more entities are being held accountable. The list of reasons for inspections is growing, and the fines themselves are really growing. Even a year ago, they were smaller than right now, and it's really possible that they will grow. Think about it. Have you ever used someone else's application without reading the agreement and the privacy policy? I'm sure you did. And I'm sure that, okay. And I'm sure developers are taking code from GitHub, not checking whether, whether this code collecting data and storing them in the right place. Of course, you shouldn't take the role of a lawyer or compliance specialist who should be responsible for that in your company, but you should just think about 3 questions. Maybe during your work, you'll find a moment to take a break and ask yourself, are we about to screw things up? And maybe are we gonna get our asses handed to us for that? Maybe you should warn the team, guys, here we will definitely screw up and will definitely be fined. And these things should be considered during the design phase, not when you'll be sitting there, we've already screwed up, we've already punished, let's think how to fix this shit. I'm sorry, but it's how it works. So here is our plan, more or less. What exactly qualifies as personal data? What are developers and system owners actually responsible for? What are the most common mistakes? How foreign regulation works. We'll speak about GDPR and United States regulation. And the most important thing, what can you start doing right now to avoid the mess later? So, most likely you think that it's obvious. What is personal data? But it's the place where misunderstanding begins, because like people mostly think that personal data is like name, individual identification number, and at best the address. But it's not quite right. According to our law on personal data and its protection, personal data refers to information related to an identified or identifiable individual. This word, this one, is the most important, identifiable. Because this means that even if you don't have a name, but have, for example, IP address, location coordinates, purchase history, unique device ID, and maybe voice or face in a video recording, and this data can basically help you to identify the particular person, the only one specific user. It is personal data. So, examples of personal data based on like practice and legislation. Full name, individual identification number, depending on the country, it can vary, of course. Email, phone number, ID details, residence, place of work. So it's the first point. Identifiers, IP address, MAC address, device ID, cookie ID. So third point is questionable, but anyway, search history, travel routes, interaction with the interface. Well, I think biometrics and photos are not questionable at all. It's fingerprints, it's voice recognition, facial recognition, and image if it can be used to identify the person. And also we have special categories of data. It's health data, racial or ethnic origin, political opinions, sexual orientation. This data require the separate consent to disclose them, or to use them, or to process, to collect, because it's really like special types of data. It is prohibited to collect this data without like separate, you cannot edit here, and explicit consent. And it's require more strict measures to collect this data, to work with it. Also, we have anonymity is not safety. It's about the fact that if you don't have name, it doesn't mean that you don't violate the law by collecting other data. The most important thing is the possibility of identification of the person. It doesn't mean that you have like Salехова Yulia in your data, but if you have my address, my cell phone number, especially my individual identification number, which can be name of the person can be easily checked in Kazakhstan using different sources that are absolutely legal, and not all of them are even like work for a price. You can just look very carefully and you can find which name corresponds to which person. So if you have this data, you have like my personal details, you can identify me. So personal data is also divided into two general groups according to our law. It's restricted access and publicly available data. What does it mean? Publicly available data refers to information that is not subject to confidentiality requirements and can be accessed freely if you have a consent. So the person can give you its consent to get an access to this data, but restricted access refers to information protected by the law. So it's fingerprints, genomic data, medical insurance tax, and other confidential records. So you cannot just get an access to this data, even if you have a consent, without special requirements fit. So what about technical identifiers? Cookies, browser fingerprints, push tokens, other things. All these things can be used and considered as personal data if they allow to track the specific user. Even if you don't personally link these IDs to a name, if someone else can, using your base, identify the particular user, this still falls under the protection of law. Only when data is anonymized and you cannot bring this data back, only this way you avoid the control of regulator, and it stops to being considered as personal data. So only at the moment when you lose a chance to bring this encrypted data back to a readable condition, only at this moment you can stop to be afraid of being punished or lose this data. So, okay, not here yet. So the general questions you can ask is, can someone be identified based on this information? Could combining this data with other available data reveal someone's identity? Who else might be able to use this data to identify someone? Do I have a legal basis for processing the data? It's a very important question. Did you receive the consent of the person? Did you receive the confirmation from the individual that this individual is agree that you collect and process the personal data? It's a very important question because it's your protection as well. So in Kazakhstan, the most important legal act that you should be aware of is the law on personal data and its protection. But we have some other laws that can be used and can be helpful during your work on informatization, on communications, and orders issued by the Minister of Digital Development. So these legal acts are covering the general principles, the requirements, the technical requirements, and requirements for your databases, server security, and data localization. The last thing is very important. We'll talk about it later. So these are the key principles of personal data processing under the law of Kazakhstan. So, respect for constitutional rights and freedoms of individuals and citizens. Like, obviously, it's a general rule. Legality, confidentiality of restricted access personal data. What we've talked about. Equality of rights and ensuring the security of individual society and the states. Other important aspects include purpose limitation. When you collect personal data, you should know what for. You should have a particular purpose of collecting this data. It can be collected only for specific and clearly defined reasons. You cannot just collect all the data like you have access to in a moment and then store it and think that it's okay. No, it doesn't work like that. Data minimization. You should only collect data that are necessary to achieve the goals for which the client give you an access to this data. Accuracy and relevance, well, obviously, storage limitation. When the purpose is fulfilled, you should destroy this data, you should destroy the information you've collected. And ensuring security, like obviously no one wants to be in the center of the scandal about the personal data disclosure. So what's the difference between operator and the owner of database? These are two subjects described in the law as well. Operator is the personal entity that organizes the collection or processing of data. And the database owner is actually the person who are storing this information and who create and manage the database. Sometimes it can be one person, of course, and one entity. And of course, it can be one person, for example, for freelancers, developers who are creating the applications, who are collecting the data. So it's a physical entity having access, collecting and storing the personal data. And it's actually the operator and the owner in one place. Consent to data processing. The law requires that personal data be processed only with the consent of the data subject. Data subject is an individual to whom this data is related, so whom it belongs. And there are some ways, some situations when this data can be collected without the consent, but they are described by law. And it's not about like individuals or legal entities. It's about the law enforcement and agencies like that who are allowed to collect this data without a consent. So what about this consent? It should be freely given. It is wrong when you are prohibit utilization of your applications without this consent, unless you need this personal data to provide customer with your service. So if it's possible to get your service without this consent and you are restricting it, it's not really right. Specific, so it's given to a particular company or particular individual in this situation. But in this particular situation, it's not like general for every time, everywhere, everything, everyone. Informed, definitely informed. So you should inform your customer. You should tell this customer which type of data you are collecting, which purposes you are collecting it for, where it will be stored, will it be transferred through the border or not? Will it be transferred to third parties or not? So only after that, customer can give you an informed consent to use, to collect and use this data. And this consent should be documented in written or electronic form and confirmed by either a digital signature or a double action confirmation. Ways of giving this consent are quite important, actually. So what information must a proper consent form include? First of all, information about operator. So business identification number and or individual identification number, name of this company or this entity whom you give this, subject's full name. So it's last name, first name, patronymic, if it exists. You should include it in the form. And that's quite a tricky thing because, for example, our Ministry for Digital Development, when they're coming with the audits to the companies, they receive the complaint for. So when they are checking, they're asking that you have to have this point, the subject's full name in the consents you collected. But how you can do this? Of course, if you have it's on the paper, it's very easy. The person just write the name there and give it to you. But if you're doing it online, the easiest way right now to get this, the easiest and probably the most correct, right, way to get this consent is to use the service, like biometric service or something, when you receive this data from the government, like from the eGov, digital government. But you will get this data only after the person will confirm. So it's a tricky thing because the person gives you consent to receive its data and its name without name of this person. So you will receive it later after this person will give a consent. And well, I don't know the answer how to avoid this thing on this stage. So probably you should ask the person to type the name before you receive the other data from from biometrics or other services. So duration of consent is also very important. You have to inform the customer how long will you store this data. And this thing is also important for regulated entities. For example, according to our legislation, if the person send you an application to revoke the consent, so you have to delete the data. But some types of companies, for example, payment organizations, like I'm working in a payment organization, we are obliged by law to store the personal data and all information about the transactions and other things for 5 years after we we cancel our agreement with the customer. So we are not allowed to destroy this data before the end of this period. So you have to inform your customer that, well, you have a right to revoke your consent, but we'll still keep your data, will not process it in any way, but we'll still keep it, we'll store it for, in our case, it's 5 years. Information about whether the operator may transfer personal data to third parties. Sometimes we are working with other companies, with other entities, and to provide our services, we need to transfer this data to receive the information from other companies and to get this information from other companies. You have to inform your customer in advance that you'll do this. And you have to inform it to which companies or for which companies you take this consent. Information on whether cross-border transfer of personal data is involved during processing. Well, it applies, for example, when you work with the foreign companies. Like same case, but your partners are in other countries. So information on whether the personal data will be made publicly available. Well, no one is reading privacy policies, trust me. It's like less than 5% of people who are really reading them and asking questions. But at the moment when someone will find the personal data publicly available, this person can come to you and ask, what the hell? Be ready for that. A list of personal data items collected about the subject and any other information specified by the owner or operator. So list of personal data items, I think it's like obvious. You have to tell your client which types of data you're collecting, how you store it. So whether it's just the name and identification number, or it's also the ID of the device and location and other things. So just inform the customer. Types of consent. So how you can confirm that the persons really agree with your conditions. Yeah, the easiest way is on the paper, but it's not always available. Electronic digital signature is also a really great way to receive this consent, because this, according to our law, this digital signature is equal to the handwriting. So if a person used this, yeah, you can confirm that, you can confirm the consent. But it's also not really comfortable to get this digital signature. So one-time password sent to the customer is quite a good way. What's a really wrong way to get this consent is to use this checkbox where you have this consent written. I mean, you don't have the action that client does. You don't have a confirmation that client agrees. You have only your own created checkbox and the consent that you imply you receive. It shouldn't work like that, because it's a violation. And if you cannot confirm that the customer does an action to confirm there's consent, you'll be fined. And information about this consent should be stored. So you should be able to provide the Ministry of Digital Development with the information about this consent, when it was given, how it was given, what time it was given. And you should be able to confirm that the customer did an action to confirm. So OTP is one of quite a good ways to do this, but we always have this problem that not all of the people have the mobile phones registered on their names. So for example, if I use my sister's mobile phone and I receive this OTP, I can then say that it wasn't me giving the consent on processing the data of Yulia Salехova. But anyway, it's something that you can then argue about, and it's something where you can make the client responsible because it's providing the wrong information by this customer. So what should happen on the backend? As I said, you have logged properly date and time, IP address, user ID, the exact version of the consent text. It's also very important, the exact version of the consent. So you have stored this text the client gave you confirmation for. Because if you change the privacy policy, for example, the customer did not give you a consent for that. And it actually doesn't work as generally with the customer agreements, where you can write there that you still keep a right to change the conditions, and if customer continues to use your service, it means that the customer is agreeing. No, it doesn't work like that with the privacy policy. So there always must be a way, a clear way to revoke the consent. So the customer always should have a right and the way to tell you that the customer doesn't want you to process the personal data anymore. And if you don't have the way, the procedure in your company to delete this data, to stop the processing, to destroy the information about the client, it means that you violate the law and the rights of this customer. So checkbox, I agree to the processing of personal data with the links to privacy policy. Sounds great, but it doesn't contain the elements required by law, so it doesn't work. A checkbox and a button saying I agree, technically yes, but still no, especially because it doesn't contain the information required by law, for example, name, first name, last name, and these things. So please work with 14 number, receive the consent using this service, and then you'll fit the gold standard. So implied consent by default, such as by continuing to use the service, you are giving your permission to processing your data, doesn't work at all. And you cannot put this agreement into the general customer agreement. There should be a separate document. Think about that. So, data localization. Our law requires you to keep personal data of Kazakhstan citizens on the territory of Kazakhstan. So, if your app is global, but if you work with the customers from Kazakhstan, the data, their data, must be stored locally, must be stored in Kazakhstan. And it's not like our regulator is crazy. I mean, it works in other countries as well. GDPR also requires this. If you process the data of European citizens, you have to at least mirrored or localized it in Kazakhstan. So, technical and organizational measures for data protection. You should protect the data from loss, unauthorized access, modification, blocking, copying, and dissemination. You have to appoint the person in your company who will be responsible for that. If you are collecting the personal data, you have to appoint the data protection officer. You should call it like whatever you want, but there should be a particular person who is responsible. Yeah, it's a legal requirement. This person should carry out the compliance control. Like normally it's compliance or security personnel. Overseeing the handling of requests from data subjects or their legal representatives. Oh, it's also quite interesting thing. You can receive the consent not only from the person itself, but from legal representative as well. But then you should check whether this person is really a legal representative and has a right to speak on behalf of someone and give this consent on behalf of someone else. Implement information security management systems, access control measures, role-based access, logging, password policies, encryption, and other things. And yeah, this person should receive the proper training and should does the proper training with the staff of the company. And obviously, if you have rules, you have punishments for violation of this rules. For example, administrative code give fines ranging from 30 to 2,000 monthly calculation indexes. MRP. 2,000. It's quite a huge amount. It's almost 8 million. Criminal liability is also possible. And I believe no one wants to be under prosecution. The general regulator for that is Ministry of Digital Development, Innovation and Aerospace Industry, MTRAP, and its internal committees and departments. So it's the main source of information, it's the main source of regulation and the main source of punishment. If you have any questions and you cannot find the reply, the answer in legal regulations, if you think that there is a collision, if you don't understand how to implement something, you can address your requests to this ministry. It's not like you have to ask them how to do your work. It doesn't work like that. But if you're really confused, if you have misunderstanding of law, if you think whether something is allowed or not, and you cannot find the direct answer in law, in our rules, you can address your request there because they are responsible. So, what can you check right now? Where is user data stored? Whether these data are encrypted. Are third-party services used? And is personal data shared with them? It's about this using the code from GitHub, for example. If you use someone else's SDKs, like applications, view them, you have to check whether they get the personal data from you, whether they collect the personal data of your customers, because it will be your responsibility, not theirs. Can user read the privacy policy and give informed consent? Whether this privacy policy contained all the information required. Can they easily revoke that consent? Is the data protected during storage, transmission, and access? Well, yeah. Don't let someone else get an access to the data of your customer. After all, you can lose your customer base, other companies in your segment can get this information and use it against you and take your customers. If you don't care about the people losing the money, losing the privacy, care about your money. Are there regular procedures for monitoring and analyzing leaks or risks of leaks? You have procedures for storing the data, and do you have incident response procedures? So normally it should work like that. You have legal framework, you have documents, procedures. So it's like a first step. You use the best practices, you use the information that you can gain on the internet using ChatGPT, whatever. You create regulation in your company and you work with this regulation. So next step, you create the system in accordance with this regulation, because I think we all agree that rarely things are working as it was planned, especially in IT. So you have the documentation, you have the plans, and then you have the application that works absolutely different and collecting the data differently and store it differently. So first step, you have this regulation. Second step, you have the system that should like somehow comply with this regulation. Third step, you have the case that's happened, and you should somehow like work with it, work with the problem that arises, work with the customer that's like really angry, work with the leak of information. So you do things. What should you do next? You should create kind of logbook where you will keep all these incidents first, and second, where you will keep and describe the steps that you implemented that can be implemented in such cases. Because sometimes when we have an incident, we're trying to, to stop the fire, but then we can think and rethink the situation and maybe find a better way to avoid it in future or to face it. So you have to document all these things. And then after you have this problem and after you cope this problem, you're going back to the first step. You're looking through all your documentation, your procedures, your local regulation, and you change it to avoid this situation happen again. And then you're going to step 2. And after you describe the new procedures, you have to implement them in your system. And then we're going back to step 3. You have a case, you have a problem, you're working with this problem, and you change first and second step. So this cycle can help you minimize your losses, hopefully. So, typical mistakes. Collecting data just in case. We've discussed it. You should not collect all the data that somehow and store it that somehow you got in your hands. It doesn't work like that. No just in case collecting of data. Customer should know what for you collect the data. And you really should use it only for these purposes you described. If you cannot use them this way, don't collect them. Using third-party code or apps without telling the user. Well, it's the point of informed consent. I gave you my consent to use my data. I didn't give it to your friend, so don't transfer my number. Don't let the marketing companies call me and suggest the products. If I didn't let you do this, don't give my number to microfinance organizations who are calling me and suggesting something. If I didn't let you do this. Again, customer mostly doesn't read the privacy policies and the customer agreements, so Stitch. So most likely they won't even know what they agreed for, but then they will fill in a complaint and they'll be right. So no privacy policy. It's actually quite a common mistake. We don't have it now, but we'll start to work, and we will soon. We'll write it and put it on our website soon. Well, the user doesn't know which data is being collected, who you share it with, how you store it, for how long it might be used. There is no document to refer in case of dispute. And it works not only for a client, because if you don't have a document to refer, customer will be right in this case. So it doesn't matter what have you done with the customer details, with the customer data. If you don't have this privacy policy, if you didn't get the agreement, you'll be responsible. Anyway, so testing with live data. When you create the test environment, test service or something, you shouldn't just copy the data and use this live data to test something, because you create the absolutely new database, and this database won't be secured in the right way, most likely. No option to revoke consent. We've already discussed that if customer cannot prevent you from processing the data, you'll be fined. Keeping data longer than necessary. So it's about not deleting the data of your customers, not deleting the dead accounts. You have to do this because, well, it depends on your policies when you have to delete this data, but anyway, you have to do this. So you should describe the time frame as well. So how long are you going to keep the data of the customers that don't use your application anymore? Well, transferring data to foreign third parties, I think it's nothing to describe here. For example, the data is hosted in Amazon, while the users are in Kazakhstan and you didn't get the consent from the customer, and you don't store it locally. 2 violations in one. So, international regulations. European GDPR. Come here. GDPR, it's a general data protection regulation working in European Union, and right now in the world, it's kind of gold standard. In the United States, you don't have the one legal act regulating the personal data processing. You have like several acts. Some of them are working locally, some of them are relating to kids, but you don't have the one. But anyway, United States refer to GDPR as a benchmark. So it's quite important if you're going to work with European or American users, it's quite important to understand what GDPR is and how it works. So lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. It's the general principles described in GDPR. And I think that you can understand that it's really similar to Kazakhstan. Or I think it's correctly to say that Kazakhstan regulation is quite close to GDPR, vice versa. So what rights are granted to customers by this GDPR? Right of access. Customer can get access to its own information. Right to erasure, to rectification, restriction of processing, right to be informed, right to data portability, right to object, right not to be subject a decision based solely on automated processing. And if you're going to work with the European customers, you should keep in mind that whether or not you own residing in European Union, anyway, GDPR will apply. Because when you process the data of European citizens, you should take into account this regulation and you should comply. And it's especially important since the fines under GDPR can be up to 20 million euro, or 4% of global turnover, wherever is higher, whichever is higher. So real cases that you can Google and find. Meta, hundreds of millions of euro in fines. Google, Amazon, TikTok, multiple penalties. So I think you can imagine how big are law departments and compliance departments in these companies. Anyway, they were fined. So no one can avoid GDPR punishment. So in the United States, there is no federal law
but there are like bench of regulation there, sectoral and state level. For example, California Consumer Privacy Act, it applies to companies that collect data related to California citizens and exceed certain thresholds, revenue and data volume. So what's really important about this act? If you're going to the United States, you have to check whether a location where you're going to work has its own legal act regulating data privacy. Because if yes, again, you have to comply, not only to general and state level acts, government level acts, but also with the state level acts. And it's quite difficult staying in Kazakhstan to find a specialist who really work with that, who really can help you and guide you through these regulations. Then, Children's Online Privacy Protection Act. This regulation refers to children under the age of 13 and requires verifiable parental consent to a list of actions. And as I said at the very beginning, there was a case when the company was fined because of violation of this act, because they collected not kids' data, but their parents' data and did not encrypt it. So there are several acts regulating medical data, banking information, and education records. What's also important for developers is Google and Apple, like internal regulations. Because when you want to upload the application, you have to comply not only with the legal framework of the government, but also with these regulations. And they require you to specify what data you collect. Well, that's okay. Our law also requires that. Explain how it's used. Again, okay. Provide options for deletion or option out. In 2024, Google Play introduced the data safety section policy, where you must disclose type of data collected, purpose of collection, whether data is shared with third parties, whether data is encrypted, whether data can be deleted. If you don't comply, application will be banned. If you write something in your privacy policy and then Google or Apple find out that your application is actually working differently, your application will be banned. And that's the case I actually faced with one of my clients when the application was banned from Google, because in this consent, the client, the privacy policy, there were listed the information that was collected, like name, email, mobile phone number, like and other things. But also, this application asked place of work, and this place of work wasn't put on the list. And that was the reason why application was banned. It most likely won't happen like very fast, because they check the applications, I think randomly. I'm not sure, but I think randomly. But if they find out, you'll have to fix it somehow. Otherwise, you won't be able to work. Cross-border data transfer. When you want to transfer the data of Kazakhstani citizens somewhere, you have to be sure that the level of protection is not lower than in Kazakhstan. You cannot transfer it to places where data protection doesn't exist, where this regulation doesn't exist. You should receive the consent to transfer data cross-border. You have to include it. If you don't have this consent, you're not allowed. Even if client gave you all the consents of this world, but if you didn't ask, am I allowed to transfer your data somewhere abroad? You're not allowed to do this. Ideally, you're storing the data here in Kazakhstan, and they're giving somewhere aggregated data and anonymized. So in this case, well, if your if your partner, if the company you're going to transfer the data cannot identify people in this data, like you can freely transfer it, but you should be sure that there is no way they can decrypt this data and receive it not in anonymized and aggregated visualization. In European Union, they use standard contractual clauses in the agreements with safe countries. In Kazakhstan, this mechanism doesn't really work, but the Personal Data Committee may prohibit cross-border transfer if safety is not guaranteed. What else? Let's come back a bit to GDPR. Data protection by design. It is required by GDPR, and it's the really great way to think about it and to work with it. You should put the data protection into system architecture, not add it later. And that's the way you can minimize your risks and the risks of your client. By default, the minimum amount of data should be collected. Data transfer, only well protected. Any forms and actions must clearly explain what you are collecting and why. So, recommendations. First of all, it's a list of questions that you can ask yourself. Why do I need this data? It's not only because of law, actually, it's because of your own work and your internal procedures as well. If you're collecting the data you don't really need, you have to store them somehow, it costs. And well, it's not only a question of law, it's also a question of economy. Do I have the user's consent? Does this consent contain all the information needed? Where is the data stored? It's not only about the localization, actually. It's not only about whether you store it in Kazakhstan or abroad. It's also about whether you store it on your own servers or somewhere else, in which basis you store it. Is it possible to one person in your company to combine all the data and to receive the customer profile in non-encrypted way? Who has access to it? You have to create and implement protection and roles, regulations in your company to be sure that personal data of your customers are not available to each and every employee of your company. There should be people responsible for that, and there should be limitations. And for example, if your database administrator can combine information from all the tables and receive the profile of your customer, it's a violation. You have to protect your customer's data from that. Is the user informed? Yeah. And can I delete the data upon request? And here, that point that we've discussed about the legal regulations on keeping the information. So whether the customer is informed that their data won't be destroyed, deleted upon request, and whether you are informed if you have to keep this data. So, the key principle is always data minimization. We all know that, like, maybe not all of us agree with that, but information is new oil, and information has a price. And the bigger is the database, the higher is the price. And of course, sometimes people are collecting information not to use it during the service providing, but to sell it. And the key principle of data protection is data minimization. Collect only the data you need. And selling this data to some like, third parties is not actually the good reason to collect it and keep it. So the main question you have to ask yourself is, do we really need this? Implement data protection by default, privacy by design. Form fields only what's necessary. No pre-checked consent boxes. Passwords are hashed, unique ID are not predictable. APIs don't expose extra fields. Backups are encrypted, and key rotation and access logs are in place. Automate compliance monitoring. You don't have to be a lawyer. There are tools that can help you stay compliant without any pain in the ass. For example, you can log who accessed the data and when, who exported tables. Do you have the alerts for large downloads? So will you see if some of your employees will download a database, information from this database? Do you have checklists where you can like put this checkboxes, cross these checkboxes to be sure that all the steps that is written in your regulation, are actually in place? How often are your policies reviewed and updated? So kind of gold standard, of course, after each incident, you have to check and look through your documentation. But even if you don't have documents, the best practice is to update it at least once a year. So have a week when you read all these documents, when you read the best practices, look through the cases that happened in the previous year and implement somehow this information in your company. And do have clear instructions for situations when things have already gone wrong. Well, consent management system, it's like, obviously you have to keep a record of consent, we discussed it. And you have to be able to find this information, to find this consent, to have the confirmation that customer gave you the consent. Enable a consent revocation mechanism and ensure data is deleted when an account is deactivated. Don't store unnecessary data, it's data minimization as a key principle again. Delete old logs and backups, review your data retention policy, and erase accounts of users who left more than, I don't know, like 1 year, for example, like 6 months. It's like about your internal policy, but anyway. And talk to your team. It is a very important thing that each and every person that's working in your company is aware about the restrictions and regulations and the measures you are trying to implement. Because, well, the most unprotected thing, I don't know, stage of each process and each secured and safety system is a customer always, but the second one is an employee. So be sure to educate your employees, be sure to talk to your team, to explain how it works, to make everyone think about collecting the data. And if, I don't know, even if the person is not responsible for that, but this person sees that you don't have a process to protect types of data you're collecting, this person should, like, I don't know, do whistleblowing, I might say so, and review code with privacy in mind. And what to do if you're not sure? Well, if you're just a developer, not the owner of the company, not the core team, make your manager have a headache. Like, why not? It shouldn't be only yours problem. Find someone else to be responsible for that. But anyway, escalate the problem. If you're not sure, escalate the problem. Consult the public sources. We have, like, we are living in the century of internet. We can find almost everything online, but if not, as I said it before, you can consult with the department, with the Ministry of Digital Development. So, what else? Okay, documents that you can use and that can be helpful. Security policy that includes personal data storage provision, access control instructions, procedures for blocking and retention. Very important thing, a list of individuals with access to personal data. A list of personal data elements that are necessary and sufficient to achieve the operator's objectives. It's not just the list to help you to keep the procedures in place. It's also a list that is required by law. So Ministry for Digital Development requires you to have the list of people who can access to personal data and to have a list of people having access to particular data. So it's not like, well, this, and this person can work with personal data. No, this person can work with these types of data. This person can work with these types of data. This person can work only with these types of data or with all the data in general, but you have to put the list there. So minimum technical measures that you can implement: encryption of backup copies, role-based access to personal data, HTTPS for all connections, password hashing, of course, login of access and actions involve personal data, regular cleanups, appointing person who will be responsible and who will have a headache, documented data processing policies, and storing personal data in the territory of Kazakhstan. One interesting thing, when you become an operator collecting huge amounts of data, you will have to work with encryption anyway. You're obliged to do this. You have to fit the particular level of certification and security. And it's the thing that you should keep in mind, because you should be able to confirm that you comply with these requirements. And if you keep a lot to be certified, because unless you are certified, unless you get the certification, you don't have other way to confirm that you comply. So you might have some issues with the regulator then. That's all, I think. If you have any questions, you can ask them now, or Telegram, or you can write to one of these pretty girls, and then they will transfer the questions to me.
Thank you so much, Yulia. Thank you, our listeners in online and offline.
You survived. You're heroes.
I hope you enjoyed this lecture. It was really useful and interesting. Thank you so much. Now there is coffee break. So thank you.
No questions? 3 questions.
Oh, okay.
Okay. Okay. Well, I think it's probably we can discuss with privacy.
Yes.
Okay.
Okay. So thank you. You can leave the room.
So thank you for coming. Thank you for staying. Thank you for listening. If you have questions, really, that would be really nice to give you an answers. I'd be happy to. And well, protect your customers, please. Hey,
У меня два вопроса. Один можно
Можно подслушивать, мне интересно. Что подслушивать?